Hello, class. Good day. My name is Nicholas Velis, and I'll be presenting contracts case. Before you watch the video, please watch the link to the commercial that I've put in the discussion. This case arises over a commercial, so you'll have a better understanding if you watch the commercial before you watch the presentation. So the case is Leonard versus PepsiCo Inc. Leonard is suing PepsiCo for breach of contract and fraud, and you will see why. So we have here Mr. Leonard, who was a male in his 20s, who resided in Washington State. He considers himself to be adventurous, young, typical of the Pepsi generation. And then we have the defendant, who is PepsiCo. I'm sure we've all had or drank or ate the products. They engage in manufacture, marketing, distribution, and sale of food, beverage, and snacks. Some of their products are pictured below. They have water, Gatorade, soda, Doritos, Ruffles. They have also cereal bars. They're worth over $11 billion, and their products are sold worldwide. So, like I said, if you watch the commercial was shown in 1996. It shows it's a new campaign that Pepsi is promoting, which is you can exchange your Pepsi points for any redeemable items that are in a catalog, in their catalog, which contains 35 items. So in the commercial, you see a Pepsi T-shirt, you see leather jackets, you see glasses that you can exchange them or redeem them for a certain amount of points. And at the end of the commercial, it shows a jet, to be specific, a Harrier jet, right? And then it's written below 7 million points. In order to exchange those points, you would have to fill out an order form in the catalog, like I said, and then you'll be able to receive your item. And it's important to note that Pepsi points can be bought. It was 10 cents will get you one Pepsi point, right? So Mr. Leonard, he saw the commercial, he was inspired, and he set out to collect 7 million points, right? But it became clear to him that to collect 7 million points off of Pepsi products was just impossible. You would have to drink 190 sodas a day, Pepsi sodas a day for 100 years. I mean, that's impossible, right? So like I said, you can buy the points, and that's what he did. He gathered family, friends, or he collected money from family and friends, and he was able to gather $700,008.50, which is the equivalent of 7 million points, or around 7 million points, right? Once he got the money, he submitted the order form, right? But in the catalog, there was no Harrier jet to redeem. So what he did was he wrote one Harrier jet as shown in your Pepsi stuff commercial. And he attached it with the check. He sent it over. PepsiCo received it, declined the request, saying the Harrier jet, they were like, oh, we apologize for the confusion. The Harrier jet is not included in the catalog. It was included in the commercial as a joke. Forgive us and sorry for the inconvenience. And they gave him like a free shirt, right? But Mr. Leonard declined, and he said he sent him another letter requesting the jet, and if the jet was not given to him within 10 days of the receival of the letter, then he was going to file appropriate action. And so what happened? PepsiCo denied the request, and they filed for declaratory judgment in New York, while Mr. Leonard, in response to that, filed for declaratory judgment in Florida, which was later transferred to New York. Why was it transferred to New York? Because it had nothing to do with Florida, so they just transferred it to New York. A declaratory judgment is a declaration by a judge in a court of law that identifies specific rights, privilege, and obligations of all parties involved, without a jury, right? So there is no jury, and there's no going to trial. So the court just decides who is responsible for what, and did this really happen, or based off of the evidence that is shown to the court. Mr. Leonard moved to dismiss PepsiCo's declaratory judgment. PepsiCo did not appeal that. Then Mr. Leonard, he saw that he wasn't going to win, and he voluntarily dismissed his suit. right, in Florida, and they agreed. The court agreed, but they were like, okay, we'll let you dismiss the suit if you pay PepsiCo's attorney's fees for litigating the case here. And so they gave him 30 days for that. Mr. Leonard failed to pay the fees and appealed to the court's fees. The court denied that appeal and saw that and told Mr. Leonard, hey, you either pay the fines or you continue litigation. Remove your dismissal and continue litigation. And what happened? Mr. Leonard continued litigation. And so he sued them for breach of contract and fraud, right? So the court needed to decide if the commercial was an offer or was it or was it just simply an advertisement, right? So they relied on the restatement second of contracts, right? And what that means is that advertisements of goods by display, sign, handbill, newspaper, radio, or television are not ordinarily intended or understood as offers to sell. The same is true of catalogs, even though the terms of suggested bargains may be stated in some detail, right? Under these principles, the plaintiff's letter with the order form and the Pepsi points constituted the offer. There would be no contract made, right? Since PepsiCo did not cash the check. Had they had cashed the check, then okay, there was a contract, but they denied the request and they even told them, hey, no reasonable objective person would have found the jet to be an offer, right? So the court concluded the commercial was merely an advertisement. The catalog didn't contain a Harrier jet, right? And no contract was made between both parties, right? And there was no unilateral offer made to Mr. Leonard, right? Then Mr. Leonard argued that from his understanding, right, he was a PepsiCo, he was young, PepsiCo generation, or typical of the PepsiCo generation, adventurous, right? He's from his understanding, the jet was an offer. He wanted a jury to decide, a jury that is similar to his personality, to decide if they would perceive the jet to be an offer, right? He didn't want the court to decide because they're completely, I mean, their personalities were different. They grew up different, whatever. So the court was like, no. We need to decide if a reasonable, objective person would perceive commercial to be an offer. Was it an offer, right? Would a reasonable, objective person perceive the commercial to be an offer? So they were like, okay, a Harrier jet, a fighter jet, right, used by the United States Marine Corps, right, that it cost around $33 million, and it's used to attack and destroy surface targets of enemies. It holds over 9,000 pounds of ammunition and projectiles, again, to just kill its enemies. In the commercial, it is shown that is being driven or piloted by a high schooler who lands the jet in front of a school, right? And he just gets out casually without checking the equipment, doesn't even have a helmet on. And to obtain 7 million points, you will need to drink, I mean, it's almost nearly impossible, right? 190 Pepsi a day for 100 years. You're also, I mean, they also concluded that the offer was, I mean, too good to be true. $700,000 will get you an equivalent of $33 million, right? So they were like, no reasonable, objective person would have thought the jet to be an offer because it was just simply a joke. The addition of the jet was made in jest. It was a joke. It was for entertainment purposes. And in regards of the breach of contract and fraud claims, for the breach of contract, the court relied on New York statute of fraud, which pretty much says that there has to be writing between both parties agreeing that the purchase of an item or something that proves that an agreement has been made between the parties, right? But there was no signature on PepsiCo's end. They didn't cash the check. They didn't agree. There was nothing. So there was no writing between the parties that evidences transactions, right? And plaintiff's order form did not bear signature of defendant. So there was There was nothing. It was on PepsiCo's end. They didn't accept the offer. There was no signature. I accept the offer. None of that. So there was no breach of contract. And to properly state a claim for fraud, the plaintiff must allege a misrepresentation or material omission by defendant on which it relied that induced plaintiff. The plaintiff was not, he wasn't induced to enter any contract. He was offering. He set the offer to PepsiCo. So the court concluded the plaintiff was not induced to enter a contract, and the defendant never had any intention of making good on the Harrier jet. So the court concluded that they saw there was no breach of contract or fraud made by PepsiCo. So at the end, we see that the court said the commercial was just an advertisement. There was no unilateral offer made. Pepsi's Stuff commercial was made in jest. The addition of a Harrier jet was just a joke. No reasonable objective person would have considered a food and beverage company to offer a fighter jet. There was not enough writing to satisfy the statute of frauds, and there was no contract made between both parties. So pretty much PepsiCo won the case, and the court granted defendant's motion for summary judgment. Any pending motions are moot, and that is the case. I do agree with the court's decision. If you watch the commercial, what came to my mind when I saw the commercial was, I thought it was entertaining. They added the jet. It was like, hey, I giggled, but a food and beverage company, a company that sells sodas offering a fighter jet that is used in the military, in times of war, that's just a huge liability on their part. Just, if they were to offer that jet, it's a huge liability. I don't think they will go through that. So, it wouldn't come to my mind that they would actually sell a jet. So I agree with the court's decision, and yeah, that is the case. And here are my references, and I hope you guys have a good rest of your day. Bye.